on the roof, her beauty in the moonlight overthrew you. She tied you to her kitchen chair, she broke your throat and she cut your hair, and from your lips she drew the hallelujah.
The owner of the land is not expected to reimburse unless, of course, he wants to retain those ornaments. If he chooses to retain those ornaments, then he must pay for it. Pero kung pwede naman tanggalin nang hindi masisira yung property, then the one who installed it can remove it. Okay, that is the indemnities mentioned in 546 and 548. Am I making any sense? Do you have any questions so far? Anyone? Let's make it a conversation. I don't claim to have all the answers, but I'll find the answers with you.
Good evening po, Attorney.
Okay.
Good evening po, Attorney.
Yes.
I have a question po. With regards po the halimbawa po, ang two requisites niya po, it must be for the purpose and paying for just pension. What if po government po wants to get private property of it is for the purpose of public purposes po and paying just compensation, the two requisites po are present. Can the owner of the private property po can bargain the price of paying for the private property po?
The just compensation required is pegged on the fair market value. So, ang ginagawa, ang proseso ngayon ng expropriation or in eminent domain is that ang gagawin ng government, they will enter property, consign with the court 10% of the price, the market price. Then, magpipetition sila sa court ng eminent domain. Then, it is the court. Sometimes the court will get the help of commissioners to determine the fair market value of the property. So, hindi siya ang fair market value is based on, say, ano ba yung value ng lupa na ipinagbili ng katabi. Doon i-base. That is the fair market value. Yung lupa noon, how much would it? Yun ang maging basis for the just compensation. Ang usually nangyayari ngayon among eminent domain cases is kino-question ng may-ari whether it is really for a public purpose. Mas madaling kung ikaw ayaw mo mawala yung property mo, doon sa presyo ng just compensation ka mag-focus. Kalabanin mo siya, ask the government to prove that it is really for a public purpose. And dapat essential na yung lupa mo yung dapat gawin, dapat kunin. Kasi for example, any of you are familiar with Katipunan Extension? Katipunan Extension is Alam mo yung Katipunan, tapos yung tatawid ka ng White Plains, the government filed eminent domain before para kunin yung Katipunan extension dahil that part is still privately owned. Ang title nun nasa isang yung developer ng White Plains. Kasi dapat ang balak ng government dati yung Libis, yung papuntang Libis na overpass, doon dadaan sa Katipunan extension. But then nagbago yung plano ng DPWH. Ang ginawa nila, yung daan, instead of passing through Katipunan extension, ibinaba nila sa Libis. So the owner of the property won his case na hindi nyo na kailangang i-expropriate itong lupang to dahil yung plano nyo, ibinaba nyo na dun sa ang ginamit nyo na ibang daan. So, wala nang use na i-expropriate. Okay? So, if a party wishes to question eminent domain proceedings, focus on the public use rather than the issue of just compensation. Any other questions?
Thank you po, Attorney.
Any other questions?
Good evening po, Attorney.
Yes.
May I ask po, ang mga property po ba na nagamit for eminent domain, limited lang po ba for public purpose such as roads or may iba pa pong example?
Well, let's make clear, the right to expropriate is not limited to government. The government may also authorize other, even private organizations to expropriate property. For example, NAPOCOR. They can expropriate property as long as it is within their mandate. Another private organization that is allowed to expropriate, Transco. Yung gumagawa ng malalaking transmission lines, they can expropriate property. Lalo na yung pagtatayuan ng mga malalaking transmission lines. Now, tanong ni Kurt, once na expropriate, fixed na ba yun? Kumbaga, is the government stopped from using it for some other purpose? The answer is no. Once it has been expropriated, and if the conditions have been changed, then the government can change its purpose. Halimbawa, from public, gawin nilang, gawin nilang patrimonial property. Gawin nilang for the development of wealth of the country, for example. Yung public purpose is only for yung initial na pagkuha. Once the government has proven that it is for a public purpose at nag-push through na yung expropriation, then tapos na yung boxing. Hindi mo na, once magbago yung conditions and pwedeng baguhin yung nature ng property, then the government can do so. However, of course, ang pwedeng magbago lang noon is Congress. Kapag ang isang property for public use at babaguhin mo yung kanyang category, then there must be a law that allows such a change. I don't know for the case of our properties in Japan. Our properties in Japan was supposed to be sold as private property, but the Supreme Court stopped the sale because they were considered to be properties for a public purpose. And if you want to change the category of a property intended for public purpose, there must be a law changing its category. So hindi rin siya ganun kadali. However, the government or the state is not stopped or is not precluded from changing category of such a property. Any other question? Did I answer your question?
Yes po, sir. Thank you po.
Okay. Any other questions? Okay. The next topic that Cindy has asked me to answer is the difference between usufruct and easements. They are very different. A usufruct is when let's start with the definition of what ownership is. Okay. Ano ba yung ownership? What does it mean to say you are the owner of a property? Okay. The best definition of what ownership is the definition of ownership being a bundle of rights. So, ano ba ang bundle of rights equivalent to ownership? Of course, the right to alienate, the right to possess, the right to use, the right to abuse or destroy the property if even, and the right to its fruits. Now, sa usufruct, it is basically a conglomeration of two of those rights, usus and fructus, referring to the right to use and the right to its fruits. Okay? So, kapag yung dalawang rights na yon given to one person, that right is called a usufruct. So, idinidivorce mo yung the right to use, right to fruits from naked. Ibig sabihin ng naked ownership, ikaw yung yung gumamit, hindi ikaw yung nakikinabang ng fruits. So, ikaw ay ari in name. You are the naked owner. But by contract or by succession, nahahati yung naked ownership at yung the right to use the property and the right to its fruits from the title of the owner. Okay? For example, ako yung may-ari. Ako yung may-ari ng property. But then, by contract or by some other device, I gave the right use and to the fruit of the person. Then that person has the right of use of fruit. Okay? So, siya yung pwedeng gumamit, siya yung kung merong fruits na napoproduce yung property, then he gets it. For example, ang property na pinag-uusapan is an apartment. Okay? It's a 2-door apartment. Yung isang door, pwedeng tirahan ng usufruct. Yung isang pwede niyang iparent. Rent is considered a fruit. Kasi nanggagaling yan dun sa use ng property. So, kahit ako yung may-ari, if the usufruct is given to some other person, hindi sa akin mapupunta yung rent. It should go to the usufructuary because he has the right to the fruits and the right to use the property. Now, how is that different from easements? Ano ba yung easements? Easements are, it involves a dominant estate and a servient estate. Okay, may dominant, may servient. Pinakamadaling example, right of way. Okay? Si lot 1 and lot 2. Okay? Si lot 2 nasa looban. Nasa looban siya. Wala siyang dadaanan kundi yung lot 1. Okay? So, depending on whether paano siya napunta doon sa dulo. Halimbawa, kung kasalanan ni lot 1, siya yung nagbenta ng lupa doon sa may-ari ng lot 2, then he is obligated to provide a right of way. Okay? So, yung right of way, yung dadaanan ni lot 2, is still owned by lot 1. However, he is not in control kasi nga ginagamit as right of way ni lot 2. Diba? It is a limitation on the use of your property. The easement is constituted for the dominant estate. Kung ikaw yung may-ari ng lupang dinadaanan, you are considered to be a servient estate. Okay? Yun ang pinakamadaling example ng easement. Well, the other easements like the easements of light and view, the easements of aqueduct, mahirap ipaliwanag without without discussing yung prerequisite provisions ng civil code. So yung right of way ang pinakamadaling example ng isang easement. An easement by definition is a limitation on your property. Okay? You are still the owner, However, you don't have full control of it because it is being used by another property. Okay? Questions? Graduating na ba kayo ng legal studies? Am I correct? So I will be seeing most of you in the College of Law in about 2-3 years or a year or two. It's very rare in the College of Law for a professor to tell you, you can ask me questions. So right now, I'm giving you that privilege because once you get into law school, it is the professors who will be asking the questions. So right now, if you have questions, then ask them now. If not, then we can end the lecture and then I'll see you in 1-2 years.
Attorney, last question po.
Okay.
Before po tayo mag-end. Is it possible daw po na mag-grant ng right of way without indemnity? If yes po, when daw po?
Walang indemnity kung legal right of way. For example, yung sinabi ko nga, ikaw yung nagbenta ng lupa sa kanya na nandun sa dulo, na walang ibang lalabasan kundi yung property mo. Then you are obligated to give him a right of way. Indemnity is given kapag voluntary easement. Yung by contract, nag-agree tayo, sige, pwede mong daanan to. Then, there should be an indemnity. But not if it is a legal right of way or a legal easement. Kasi kapag legal easement, because it is your fault for placing him there and not providing him with any access, then you are obligated to provide him one. Kaya walang indemnity. If it's a legal easement, legal easement of right of way. There is indemnity in voluntary easements. Yung nag-agree tayo, by contract, nag-agree tayo, and hindi siya legal easement kasi meron naman siyang ibang dadaanan, mas malayo nga lang. But gusto niya dumaan doon sa lupa mo, halimbawa, then he must pay the indemnity. And that is only if you would agree. Di ba? Kaya merong indemnity kasi gagamitin yung property mo as a right of way.
Thank you po.
Any other questions?
Sir, na-curious lang, attorney, na-curious lang po ako sa power of eminent domain. Kasi po, may sinusunod po bang moral or ethical standards ang government when seizing or when taking over other people's or the citizens' properties? Kasi po, napanood ko po dati na may landowners po sa China and they refused the government na mag-take over sa lupa nila. So, ang ginawa po ng government is tinayo po yung highway sa left and right po mismo ng house, leaving them in the middle of the highway.
Actually, wala namang ganyan nangyari pa sa Pilipinas, I think. And kapag expropriate ang government, it's the whole land. Forced yung coercive ang pagkuha ng lupa, whether you like it or not. Kasi mahirap naman yun na magkaroon ng bahay sa gitna ng highway. It would cause accidents. It would not be safe. So the government, yung nasa gitna, the government will also expropriate it. As for moral or ethical, I think the only bar that the government must prove it is that it is for a public purpose. And being of a public purpose, it is yung need niya is higher than the private need to keep the property. It is serving the interest of the majority. Yun yung ethical bars probably that the government must prove. That mas masaserve ang marami by doing that project and maserve ang public purpose. So, yun na siguro ang pinaka-ethical or moral standard na pwede nating sabihin. Did I answer your question?
Opo, attorney. Yun po ba yung dahilan kung bakit may mga resettlement areas po yung mga squatters kapag pinapaalis po ng government sa lupa po ng mga illegal na nakatira?
That is the Lina law. The government is obligated to find resettlement areas for people who are occupying public properties. Kapag public property yan, if it is owned by the government, then the government must find them a resettlement area before they can be demolished. That is not applicable if the people are occupying private properties. Pag private properties, pag nag-demolish ang court, there is no obligation to find you a resettlement area. It is only for people occupying public properties. Okay. Halimbawa, yung saan ba ang last? I think yung mga squatter dun sa somewhere in Agham Road in Quezon City. They were occupying a piece of land owned by the government. When they were demolished, meron agad silang paglilipatan. And that is provided for by the law principally sponsored by Senator Joey Lina, I think. Now, it is called the Lina law. Any other questions? If you have no other questions, then I'm stopping here, and I'll see you in the College of Law a year or two from now. Okay? Good luck.
Thank you so much po, Attorney De Guzman, for your very fruitful lecture. Siksik, liglig na lecture para sa aming lahat. And of course, habang magle-lecture po kayo, meron lang po ako mga isinulat na notes sa ating lecture. So, run through ko lang po para ma-summarize natin ang lecture ni Attorney. First, Attorney De Guzman assisted us in tracing the history of property law, where the first group of people owned everything in common, and that the concept of property can be traced to the development of civilization. Now, we also differ in the history of our civil code. Our civil code is based on the Spanish Civil Code, and the Spanish Civil Code is based on the Code of Napoleon from France. The Code of Napoleon is based on the Roman law. Now, we also discussed about the eminent domain. And eminent domain is a government power that allows local and national entities to acquire private property. And gaya ng sinabi sa atin ni attorney, meron tayong dalawang requisites, for public purpose, and dapat may just compensation. Now, we also discussed other principles in property law, such as possession in good faith, na Article 448 and Article 546. Now, attorney also defined ownership. Mas ika nga ni attorney, ownership is a bundle of rights. Right to alienate, to possess, to use, to abuse, or even destroy, and the right to its fruits. Now, pinag-usapan din natin yung usufruct and easements. So, sana po lahat tayo ay may natutunan at may baon mula kay attorney ngayong gabi. So, again, thank you so much po, attorney Guzman. So, can we ask our participants to open their cameras for a quick photo opportunity with Attorney J?
Pa-off ko muna nung naka-share screen. Thank you po. Ready po. 1, 2, 3. Isa pa po. 1, 2, 3. Thank you po.
Okay. Have a good night, and as I said, I'll see you when you enter the college. Bye-bye.
Thank you again, attorney. Now, on to our next lecturer. He is a graduate of a BS Business Administration, major in Entrepreneurial Management, and a Bachelor of Law degree holder. He is a licensed real estate broker since 2015 and passed the bar exam in 2018. He is a member of the Associate of the Philippine Institute of Arbiters since 2015. He is a professor of law in De La Salle University, Dasmariñas, and a corporate secretary of Genrom Logistics Incorporated, and the managing partner of the law firm of Buena, Reyes, Francisco, and San Pedro Ladignon. Now, please welcome Attorney Mark Nel Francisco.
Hello guys, good evening. How are you guys doing? Kaya pa ba? Proceed pa tayo, no? Kaya pa. So, I hope that all of you are doing good, doing fine at the very least. And it is truly a privilege for me to join you tonight in your lecture series. But to be candid, ang supposed na lecturer for this evening was Attorney Reyes. No, so si Attorney Reyes kasi is not only a professor, he's also a public servant. So due to conflicting schedule, binanggit niya sa akin to kagabi. And being like a father figure to me, so syempre I cannot refuse. Wala tayong magagawa kundi sa ibigay ang ating matamis na oo para sa ating parang magulang, di ba? So I hope I'll do justice to the supposed lecture of Attorney Reyes. I was informed na ang topic for this evening is basics of Philippine labor laws. So I asked Cody yesterday evening kung nakapag-take up na ba ng labor laws ang mga participants. So he informed me na majority daw ay hindi pa nakapag-take up ng labor law subjects. So in law school proper, ang labor law ay divided into two. So you have labor standards and you have labor relations. So as to period, yung lab rel, meron pang kasamang labor law review ay 3 semesters. So for this evening, magfo-focus lang tayo dun sa important na parts nitong lab stand. At insofar as lab rel is concerned, syempre ang napag-usapan namin ni Attorney Reyes is that we'll do that on a later schedule na lang siguro. Lab stand muna tayo ngayon. Kasi yung lab rel ay prerequisite niya yung lab stand. So it would be difficult for the students, especially yung mga hindi pa nakapag-take up ng labor law, to understand yung provisions ng lab rel. So, in that regard, mag-start muna tayo sa lab stand. So, by the way guys, naririnig nyo ba ako ng malinaw? Clear naman. Okay, so I'll share my PowerPoint presentation. A window. Ayan ba po? CD? No. Ako cover pala ng buwan. By the way guys, if you have questions, comment na lang dun sa ating chat box para ma-address natin later on. So, I'll proceed with our lecture. Basics of Philippine Labor Law. So, first question is, bakit ba importante na matutunan natin yung labor law? So, why is it important? First, of course, important yung labor law sa ating buhay. Why is it? Why is that? Because maging employer ka man, maging employee ka man later on, nag-govern ng laws on labor yung pakikitungo mo hindi lamang sa state, kundi pati na rin sa iyong employees. Pero kung ikaw ay employees, kung ano yung mga standards na kailangan ibinibigay sa iyo ng iyong employer. So, as future lawyers, important din to sa inyo, guys, because isa ito sa mga pwede ninyong i-explore as your practice area pagka kayo ay naging member na ng bar in the future. So, if you feel for those who have less in life, you can represent the labor sector, yung mga employees. So, kung kayo naman ay into corporate or into representing businesses or individuals, pwede rin na individuals o businesses, of course, employer side naman yun. So, magagamit ninyo yung inyong matututunan sa labor laws. So, the Article 1700 of the Civil Code provides that the relations between capital and labor are not merely contractual. So, they are so impressed with public interest that labor contracts must yield to the common good. Itong labor daw, class, ay hindi lamang contractual. So hindi lamang yan yung tipong pinirmahan mo, nag-enter ka into an employment contract. So yan ay impressed with public interest. In such that labor contracts must yield to the common good. So hindi lamang limited sa labor law yung provisions. From time to time, kapag inaral nyo na yung labor laws, babalik kayo sa civil code, babalik kayo sa constitution. So civil code, yan yung isa sa mga provisions na related sa labor. So, 1702 of the Civil Code further provides that in case of doubt, all labor legislation and all labor contracts shall be construed in favor of the safety and decent living of the laborer. Bakit guys? Because yung labor in contemplation of law ay property right. So hindi lang siya merely contractual, isa siyang property right. So kung kagaya ng lupa na pag-aari ng isang tao, yung iyong pag-iempleyo, yan ay considered din as pag-aari mo. Lalo na kapag meron ka ng security of tenure or if you are already a regular employee. So may mga dapat na ibinibigay sa yung minimum standards. Yan ay in accordance with the provisions of the Labor Code. So, construction in favor of labor. All doubts in the implementation and interpretation of the provisions of this code, including yung IRR or yung implementing rules and regulations, shall be resolved in favor of labor. So this is in consonance with the constitutional provision and doctrine that those who have less in life must have more in laws. So, kino-consider ni state na dapat lahat ng doubts pagdating sa implementation and interpretation, construed yan in favor of labor. So medyo tinitilt. Because under the timely settled doctrine, yung mga laborers considered yan as medyo nasa less in life na aspect, na nakadepende lang sila sa kanilang empleyo, karamihan sa kanila. Kaya kung meron mang doubt, kailangan yan ay nire-resolve in favor of labor. Yan din ang nangyayari based on my experience sa pagpapractice sa labor laws. I've handled several labor law related cases. So pagka may konting problem or medyo may in doubt when it comes to the pieces of evidence which were adduced, if there are doubts insofar as the implementation or interpretation of the law in relation to the facts, yan ay tinitilt ng arbiters in favor of labor. Kaya nga nung nag-uumpisa pa lang ako, sinasabi sa akin ng aking boss na, you know Mark, sabi niya, 99.9% of the time, kapag ka ang employer ay na-filean ng labor case, may nakukuhang monetary amount or may nakukuhang award ang complainant. So at the time, hindi ko pa siya na-appreciate. Pero doon nagsimula na ako mag-handle ng labor cases, I realized na totoo pala yung sinasabi ng aking boss na it's only a matter of how much will the employee get pagdating sa labor cases. Pero wala pa ako na-experience in my almost 4 years ng pagpapractice sa labor cases. Wala pa ako na-experience na totaling zero yung nakuha ng employee. So all the time, may nakukuha siyang monetary award. It's just a matter of how much yung makukuha niya. That is why, with that in mind, pagka ako ay nag-handle ng labor cases, I try my best na sa mediation pa lang, ma-settle na. In-explain ko sa aking client na, ma'am, pagka po ito ay umabot sa resolution ng case, 99.9% of the time, may makukuha yung employee. Bakit? Because of this provision and yung mga doctrines ng ating constitution. So, yun. So, yan. It also applies pagdating sa appreciation ng evidence in labor proceedings. So, pagka may doubt sa evidence na pinresent ng employer at ng employee, the scale of justice must be tilted in favor of the employee. So, yan. As enunciated in the case of Dreamland Hotel Resort versus Johnson. So, we discussed labor standards. First thing na dapat ninyong matutunan pagdating sa LabStan ay yung test to determine the existence of an employer-employee relationship. So, we have two. Fourfold test and the two-tiered test. Under the fourfold test, so merong 4 na dapat tayong tandaan, guys. First is the selection and engagement of employees. Second is the payment of wages. Third is the power of dismissal. And fourth, and the most important among all, is the power to control the employee with respect to the means and methods by which the work is to be accomplished. So ito yung titignan natin. Bakit ito important? Later on, marirealize nyo class kung bakit important na malaman natin kung meron bang employer-employee relationship. Para malaman natin yun, one, magagamit natin tong fourfold test. Una, titignan natin kung yung alleged employer ba ang nag-select at nag-engage ng employee? Pangalawa, yung bang alleged employer ang nagbabayad ng sahod ng employee? Third, yung bang alleged employer ang may power of dismissal, or does the employer have the power to not only to hire but to fire the employee? And last and most important, merong bang power yung alleged employer with respect to the means and methods by which the work is to be accomplished ng employee? Very important tong fourth na requirement under the fourfold test, class. Kasi this distinguishes yung employee mo from that of an independent contractor or that of yung mga members ng LL, legitimate labor contracting ng mga organizations, di ba? Important yan. Next, we have two-tiered test. So under the two-tiered test, yung power to control the employee with respect to the means and methods by which the work is to be accomplished. So similar siya dun sa control test kanina under the fourfold test. Next is the underlying economic realities of the activity or relationship. So dito rin makikita natin kung one of the important aspects to remember is yung kapag paano ba malalaman kung regular yan or hindi, di ba? So isa sa mga tinitingnan guys is if the employee performs work which is necessary and desirable in the conduct of the business of the employer. Yan. Pwede nating masabi na yan ay regular employee niya, di ba? Lalo na pag nag-lapse na yung period of time ng probationary employment. Important yan guys kasi more often than not, tinatanggi ng mga employers yan pagdating sa labor cases. Sinasabi nila, hindi ko empleyado yan. Or kung di man, hindi, ano lang yan? Piece rate worker yan or independent contractor yan. Diba? Bakit ginagawa ng employers yun, class? Later on, you'll learn kung bakit. Because, pag na-distinguish siya, nakita ng arbiter na, ay, regular employee mo to, may kaakibat yun na certain requirements na dapat i-comply si employer. As compared to yung ibang types na katulad ng members or employees of legitimate labor contractors or independent contractors, as the case may be. So, ibang treatment yan pagdating sa batas. Next, we study yung kinds of employment. So first, yung regular employees na mention natin kanina, referring to those who have been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. So yan. Project employees, referring to those whose employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of engagement. Regular employees. So example, kung yan ay isang tin can manufacturing company at ikaw ang gumagawa ng tin can, by definition, pasok ka. Kasi yung pine-perform mong activity, kung wala ka, hindi makakapag-produce ng tin can yung company, di ba? Kasi kung mismo yung nagawa ng tin can. So yun, usually necessary or desirable in the usual business of the employer yan. How about yung security guards nung mismong tin can company? By definition ba, pwede silang makonsider kaagad na regular employee based on the definition? I'll argue na hindi. Why? Because kahit walang security guard yung isang manufacturing company, albeit may expose siya sa risk ng mga threats na pwedeng manakawan and all, still kaya nilang mag-manufacture ng tin cans. So hindi usually necessary or desirable sa conduct ng business or trade of the employer yung pine-perform ng security guard. Yan. Pag project employees naman guys, titingnan mo yung project employment contract. So dapat naka-fix na dun kung saang phase lang ng isang project, kung saang division lang siya, kung gaano katagal lamang yung kanyang i-perform and yung activities na gagawin niya for that project employees. Usually, makikita nyo to sa construction industry. So pag construction kasi, pag gagawa ng building, dinidivide yan into phases. Phase 1, phase 2, phase 3. So kung yan ay malalaking subcon pa nila. Ang maglalatag ng mga bakal, ikaw buboost. So kung ang nalang ng employer na build or pag-construct ng building na yan ay yung pagbuboost ng semento na dapat ay tatagal lamang ng months. So naka-indicate yan sa contract mo. Ikaw ay project employee na yung iyong services will only be up to this space, specific for 3 months or until the project is completed o hanggang ma-construct lamang yung structure or building. So yan, project employees yan. We have seasonal employees. So referring to those who perform services which are seasonal in nature. And the employment is for the duration. So saan to makikita usually, guys? Makikita nyo itong seasonal employees sa agricultural industry. So yung mga pakyawan na tinatawag nila, yung mga nagpuputol ng tubo na ginagawang asukal, yung mga nag-harvest ng fruits or nag-harvest ng vegetables na seasonal in nature. Diba? So yung kanilang employment for that season only. So after na matapos ng harvest season, wala na ulit. Severed na or pwede na silang maggawa ng ibang activities. Casual employees. Pag hindi nagfo-fall sa regular, sa project, or sa seasonal employees, mo consider yan as casual employees. So next we have probationary employees whose employment does not exceed 6 months from the date of the employee started working. So unless yan ay covered ng apprenticeship or agreement stipulating for a longer period. Next we have fixed-term employees. So ito by jurisprudence, not included sa definition under the labor code, but based on settled jurisprudence, sinasabi ng Korte Suprema, meron pang isa, fixed-term employees, which refer to those whose employment contract specifies that the same will last only for a definite period, fixed term. So kung yung kanina per project, sa project employees, per phase or per project ang usapan, tapos meron siyang fixed period. Pag fixed term employee, regardless kung may project or wala, fixed term lang. Kung 5 months lang yan, 5 months lang yan. So yun yung distinction niya. As to scope, all employees in all establishments, I'm pertaining to Labstan, all employees in all establishments, whether for profit or not, are covered by the law on labor standards. So you remember guys, yung for whether for profit or not. So this includes yung mga Yung mga for non-profit na companies, di ba? So hindi lamang siya limited to those businesses which are performing proprietary functions. They also apply the provisions under Title 1 Book 3 of the Labor Code also applies to those organizations which are considered as non-profit. Are there excluded employees? So, you remember class, almost all of the time, pagka merong rule, merong exception. There's a general rule, there are more often than not, exceptions to the general rule. So, kung sinasabi kanina, applicable yung standards sa lahat ng employees in all establishments, whether for profit or not, meron tayong exceptions. Meron tayong excluded employees. Ano-ano yun? First, you have government employees. So not limited to government lang mismo. Pwede yung government agencies, instrumentalities, or political subdivisions of the government. Ang kailangan nyo lang tandaan dyan guys, kailangan yan ay not incorporated under the Corporation Code. Pagka yan ay incorporated under the Corporation Code, of course, hindi siya magpa-fall sa exemption. Anong reason? Because they are governed by a different law. Itong mga government employees na to. Sila ay governed by the Civil Service Law. Next, we have managerial employees and members of the managerial staff. So, pag managerial employees, yan ang primary duty niyan ay management and establishment. So, siya ang nagdadirect ng work for 2 or more employees and they have the authority to hire or fire employees of lower rank. Next, we have managerial staff. So, yung performance ng work niya ay directly related sa management policies ng kanilang employer. Ano pa? Yung mga excluded employees. By the way, guys, you can check yung enumeration under Article 82 of the Labor Code. So, it would be best kung makomit ninyo sa memory yung list ng mga exemption, yung mga employees that are not covered. So, members of the family of the employer who are dependent on him for support. You remember, dapat pagka members ng family ng employer yan, dependent sa kanya for support. So, ano pa? Domestic servants and persons in the personal service of another. So, yan. Exempted din yan. We also have workers paid by result. So, ano to? Ito yung mga hindi tinitingnan yung gaano katagal or gaano kahirap yung pinerform mong work. So, ang binabayaran sa'yo ay yung result ng iyong tinrabaho, regardless of the number of hours that you used para mai-produce mo yung product. So, non-agricultural employees, field personnel. So, ito yung mga hindi na susukat nung employer kung talagang ilang hours yung tinrabaho mo because most of the time nasa field ka. So, you are away from the principal or branch office or place of business ng employer. So, first, ano-ano ba yung mga labor standards na nabanggit natin, na didiscuss natin? We have normal hours of work. Pagdating sa normal hours of work, guys, ano ba? So, dapat yan ay shall not exceed 8 hours a day under Article 83 of the Labor Code. So, exemptions ba? The answer is yes. Ano-ano yung exemptions? First, pagdating sa health personnel. So may rule tayo, may specific rules tayo pagdating sa health personnel. So pagka ang population ay at least 1 million at ang hospital and clinics ay may bed capacity of at least 100. So ang regular working hours nila ay 8 hours a day for 5 days a week or 40 hours a week. Exclusive yon ng time for meals. Next, pagka in case of exigencies like yung na-experience natin itong for the past 2 years with the advent of the pandemic. So, they may work for 6 days or 48 hours but are entitled to additional compensation of at least 30% of their regular wage. Okay? Ano pa ba? Sa labor law, meron din tayo tinatawag na compressed work week. So, from the term compressed, kinompress, no? Yung work week. So, ang CWW or ang compressed work week is an alternative arrangement whereby the normal work week is reduced to less than 6 days. But the total number of normal hours per week remains at 48 hours. So, since ni-reduce yung number of days na magtatrabaho ka, in effect, yung 8 hours, syempre, mag-i-increase. So, kasi kailangan ma-maintain yung 48 hours na number of hours work within the week. So, yun. Kaya siya nag-i-exceed sa normal hours of work. Yan. So, that's without corresponding overtime premium. So, importante na matutunan ninyo yung basics like yung 8 hours na normal hours of work. Kasi later on, may mga principles tayo na i-correlate dun sa normal hours of work. Paano pag nag-exceed, di ba? So, you remember din na pagdating sa compressed work week, dapat yan ay voluntarily, expressly and voluntarily supported by majority of employees affected. Dapat ang work is non-hazardous or kung hazardous man yan, dapat may certification coming from an accredited safety organization na yung firm safety committee, ang work beyond 8 hours ay within the limits or levels of exposure dun sa occupational safety and health standards. So, last, kailangan notified si DOLE. So, yun ang common mistake nung ibang employers. Magpapa-compress work week kasi hindi notify si DOLE, no? Kailangan yan because yan ay isa sa mga requisites pagdating sa valid na CWW arrangement. So, anong rationale or what is the raison d'etre pagdating sa normal hours of work? So, the reason behind normal work hours, is to safeguard the health and welfare of the laborer and to minimize unemployment by utilizing different shifts. So, dalawa, no? Para ma-safeguard yung health and welfare. Of course, kung palaging 12 oras or 14 hours, 16 hours ang trabaho mo sa isang araw, so malalaspag, magde-depreciate ang katawan ng employee. Ayaw ng state niyan. So, pinoprotektahan niya yung health and welfare ng laborer. Second, of course, kung 8 hours lang, syempre, mas maraming may empleyo. Yung mga ibang companies na nagro-rotate, like yung mga manufacturing companies na kailangan 24 oras, dire-diretso yung pagpapatakbo. No? So, instead na isa lang or dalawang shift lang, 8 hours, so pwedeng mga around 3, minsan, 3 to 4. So, around 3 shifts per day. So, ang effect nun, syempre, kung ilan yung tao mo per shift, so, mas marami kang nakukuhang employees. So, maganda yon because yun ang isa sa mga pinoprotektahan din ng state. No? So, yung right mo to your security of tenure and to employment. Compensable hours. So, kailan ba dapat bayaran ng employer yung employee? So, all the time which an employee is required to be on duty or to be at a prescribed workplace. Yan. All the time kapag ang employee ay nag-suffer or permitted to work. So, rest periods of short duration. Kasama din yan sa compensable hours. Kasama din dyan yung power interruption. So, yung rules sa power interruption. Brownouts of short duration, pag less than 20 minutes yan, dapat bayad pa rin ng employee. Brownouts running for more than 20 minutes, hindi yan mo consider na hours work kapag pwedeng mag-leave ng workplace yung employees. So yung employees can use the time effectively for their own interest. So yan ang titingnan nyo guys. Pagka compensable ba o hindi? Pag not exceeding 20 minutes, yan ay compensable pa rin. Pag more than 20 minutes, tingnan nyo yung dalawang factors na na-mention. Kung pwede ba siyang mag-leave, kung ang employee ba ay pwede mag-leave sa kanyang workplace at pwede niya magamit yung oras para sa kanyang sariling interest. So, yun ang titingnan. How about meal break? So, meal periods would not be less than 60 minutes. So, it is non-compensable generally, except when during the so-called meal period, the laborers are required to stand by for emergency work. So remember class, you remember guys, na kapag ka less than 60 minutes, non-compensable. Pagka yan ay kahit na less than 60 minutes pero ni-require ka to stand by for emergency work or hindi mo magamit yung oras para sa pang-sarili mong interest, di ba? So yan ay considered pa rin as hours work. Okay? So, meal period, pagka less than 60 minutes, but should not be less than 20 minutes. So, must be with full pay. So, skip na natin para ma-cover natin yung iba. Waiting time. So, considered pa rin yan, kahit na ikaw ay nag-aantay lang, yung waiting time, considered pa rin na hours work yan. Pagka yung waiting time ay integral part of your work, pagka yung employee is required or engaged by the employer to wait. Hanggang kasama sa pagtatrabaho mo yung pag-aantay. Like yung, for instance, may one case na ni-rule yung Supreme Court wherein considered pa rin na compensable hours kahit na sa loob ng 8 hours na shift nung employee, meron siyang 1 o 2 oras na pahinga. Kasi yung work niya mag-unload ng mga products from trucks na unload niya. Pag dumating ang truck, buksan, i-unload, ilalagay sa warehouse yung mga products. Pag alis ng truck, natutulog siya, yung employee. Maya-maya, dalating ulit yung truck, gising, bukas, unload. So sabi nung employer, bakit ko babayaran yung 1 oras, 2 oras din, tulog ka lang naman. So, ang sabi ng Supreme Court, compensable yan. Kasi, integral part of work niya yun eh. Siyempre, pag walang truck, walang ina-unload. Pero still, required siya na nandun kasi may dadating pang truck tapos mag-unload pa ulit siya within that 8-hour period. So, na-consider siya as compensable. Next, when the employee is required to remain on call in the employer's premises. So, yan, on call ka, compensable pa rin yan. So, yung formal, as to travel time, pagka formal travel time from home to work, so pagpapasok ka sa trabaho, hindi yan considered as work time, generally. So, anong exceptions? First, pagka ang worker ay made to work on an emergency where call and travel is necessary papunta sa workplace. Okay? Travel is done through a conveyance provided by an employer. Makikita nyo, di ba, may mga shuttle na pinoprovide yung mga employer. So, yan. Travel is done under the supervision and control of the employer. So, kung pati yung travel mo, controlled ng iyong employer, no? And travel is done under vexing and dangerous circumstances. So, yan. Overtime. So, kanina, di ba, natutunan natin yung hours work, which is 8 hours per day. So, pagdating sa overtime, yung service rendered in excess of and in addition to the 8 hours na na-mention natin kanina. On ordinary working days, and I considered overtime work. So, how about overtime pay? Ano ba yung overtime pay? So, yun yung wage na binabayad natin sa isang empleyado dun sa kanyang pag-perform ng work in excess of the 8 hours a day. Yan, overtime pay yan. So, the amount of which is obtained by multiplying the applicable hourly rate of an employee by the number of hours that he worked in excess of 8 hours. So, kung nakaka-receive siya ng 500 pesos for 8 hours, you divide the 500 pesos by 8. So, nakukuha mo ngayon yung hourly rate ng employee. So, you multiply that with the number of hours na siya ay nag-overtime, nag-render ng overtime work. So, yun. Ganun ang pag-compute. So, as to rates, pag ordinary day, plus 25%. Pag rest day or special holiday, plus 30% of the basic hourly rate. So, which includes 30% additional compensation. Pag rest day naman, na nag-fall sa special holiday, so plus 30% of the basic hourly rate at must include 50% additional compensation. So pag regular holiday naman, plus 30% of the basic hourly rate, which includes 100% compensation. So, ito yung dapat niyong tandaan, class. So, from my experience sa pag-handle ng labor cases, hindi pa ako nalulusutan sa overtime pay. So, karamihan nung mga employees na nag-claim na illegally dismissed ako, attorney. Tinanggal ako, minura ako, sabihin niya, wag na daw ako bumalik. Tanggal na daw ako, mga ganyan. Tapos nag-claim sila ng overtime. So, lahat sila hindi nakakalusot pagdating sa overtime pay. Bakit, class? And bakit, guys? Kasi, pag overtime pay ang pinag-uusapan, you have to remember, kailangan may sufficient proof that said overtime work was actually performed before an employee may avail of the same. So when it comes to overtime pay, it is the burden of the employee to prove na siya ay pinag-render ng overtime work. So in the absence of evidence na meron siyang pinperform na OT, hindi yan binibigay ng arbiter, ng NLRC. So you remember, sa general rule, hindi natin pwedeng puwersahin yung employee to render overtime work. Why? It is against the employee's constitutional right. No? So baka makonsider yan as involuntary servitude. So bawal yan, generally. So may exceptions ba? Yes. So ano-ano yung exceptions? Take note na pag ang bansa mo is at war, or when any other national or local emergency has been declared by the National Assembly. So to prevent loss of life or property in case of imminent danger to public safety. So makikita nyo guys, pagka pwede kang i-require mag-overtime, extreme circumstances yan, extreme situations. May gera na, to prevent loss of life or property, may imminent danger, may urgent work to be performed on machines. So, work is necessary to prevent loss or damage to perishable goods. Why? Of course, the nature of perishable goods, so nabubulok yan. Kaya important na dire-diretso ang trabaho. So, when completion or continuation of work started before the 8 hour is necessary. So, kailangan tuloy-tuloy para ma-prevent yung obstruction or prejudice to the business operations of the employer. So, yan. You remember the exceptions, class. An employer dismiss an employee who refuses to perform overtime work. Pwede ba yan? Pagka, oy, A, mag-overtime ka. Kasi ayoko mag-overtime. Pwede ba? Pwede ba? Pagka yan ay under the instances ng Article 89 of the Labor Code, so exceptions. The answer, guys, is yes. Anong reason? In the book of Pokis, Dean Pokis of the UST College, the College of Law. So it would be an act of insubordination on the part of the worker if he unjustifiably refuses to render such overtime work. Sabi pa niya, it would be the highest form of disloyalty against the country if such work is needed to meet a national emergency. So nagkakagera na, pinag-overtime ka, tapos sabi mo, hindi. So, pwede ba? So, by way of exception, pwede. No? Kasi ang general rule ba, hindi mo pwedeng puwersahin eh. So, ito yung exceptional circumstance. Pwede bang i-offset? So, ito naman ang situation. Sige, mag-undertime ako ngayon. 5 hours lang ako magtatrabaho today. Bukas, yung trabaho ko naman, 8 plus yung in-under ko na 3. So, 11 hours naman ako bukas. Babawiin ko na lang, sir. Pwede ba? The answer is no. It is prohibited by law because it would result in the undue deprivation of the employee's overtime premium. You remember, guys, na pagka OT pay, may special rate, di ba? May dagdag. So, sabi ng batas, prohibited yan. Kasi pag offset lang tayo, made-deprive yung employees ng kanilang overtime premium. So, anong dapat gawin pagka ganun? Sabi ng Supreme Court, the proper method should be to deduct undertime or absences against the employee's accrued leave. So, as against leave na lang, kasi pareho yung rate niyan eh. No? Pero pag nag-overtime siya, dapat yung overtime niya bayad. Tapos ang rate niyan is yung rate provided by law pagdating sa overtime. So yung na-mention natin kanina. NSD, Night Shift Differential. Sorry guys, okay lang ba? Diretso natin. I was told na hanggang 7:30 lang tayo. Okay lang ba sa inyo? Diretso natin siguro hanggang, can you give me guys at least hanggang 8 p.m.? Okay lang ba? Okay lang. So I'll proceed Proceed. If you have questions, by the way, you just send them sa chat box para natin. So ma-answer natin later on. Or kung hindi man ma-answer ngayon, makopya ko yung mga tanong para I can send you yung corresponding answer sa question for the benefit of the participants. Okay, I'll proceed. So, NSD or Night Shift Differential. Sorry. So, na tayo. Ano naman to? Night Shift Differential or NSD. So, ang Night Shift Differential, guys, ay additional compensation of not less than 10% of an employee's regular wage for every hour worked between 10 in the evening up to 6 in the morning, whether or not such period is part of the worker's regular shift. So, pagdating sa NSD, you commit to memory na not less than 10%. So, dapat at least 10% yan. Pag ang employee ay nag-work ng 10 p.m. up to 6 a.m. So, every hour nga, no? So, meron siyang night shift differential. Sino ang entitled sa NSD or sa night shift differential? As a general rule, all employees are entitled to NSD. So, except yung mga na-mention nina under Article 82 of the Labor Code. So, yung mga government employees, managers, field personnel, person in service of the other. So, yan. Second, employees of retail and service establishments, regularly employing not more than 5 workers. So, pagka not more than 5, yung iyong empleyado sa retail and service establishment mo, so hindi ka compelled by law na magbayad ng night shift differential. Next, we have rest periods. So, what is a weekly rest day? So it is a rest period of not less than 24 consecutive hours after every 6 consecutive normal workday. Ang employee sunod-sunod na araw, sunod nagtatrabaho, na araw dapat yan ay rest day na. So, all establishments and enterprises may open business on Sundays and holidays, provided na meron silang rest day. Consonants dito sa article ng Labor Code. So kaya Monday may pasok, pero Monday or Tuesday, yun ang rest day nila. So yan ang rule. Every 6 consecutive days, kailangan yung susunod, rest day. Who determines the employee's weekly rest day? Sino ba? Employee ba dapat ang nagdi-dictate or employer ba dapat? So generally, the employer, but subject to the following. So kung may CBA or may collective bargaining agreement between the employer, and the employees, so kung iba nakasulat doon, yun ang mag-govern. Rules and regulations issued by Secretary of Labor and employees' preference based on religious grounds. Emergency work on rest day. Require ni employer si employee na mag-work on a rest day? The answer is no. I-require ni employer yung kanyang employees to work on a rest. Pero exceptions, katulad nung kanina, may mga exceptions. So urgent work, prevent loss or damage to perishable goods, similar. In case of actual or impending emergencies, so yan. Kung may mga typhoons, to prevent loss of life and property. So when the nature of the work requires continuous operation, so similar siya dun sa exceptions natin na mentioned kanina. Kung kailan pwede i-require you. So, analogous to the foregoing. As to ano ba choice sa day or holiday? So, pagka scheduled rest day mo pinerform, may plus 30% of regular wage ka. Pag no regular work days and no specific rest days, 30% of the regular wage day. So pagka naman yan ay work on a Sunday, 30%. Pag work on special holiday, 30%. Pagdating sa work on special holiday, falling on scheduled rest day, plus 50% yan. Pag yan ay work on regular holiday, falling on a scheduled rest day at 260% of regular wage. Now in holiday pay. Holiday pay, guys, ang definition niyan ay it is a form of premium paid to an employee not work on regular holidays. So pagka siya ay pag holiday pay, we have to distinguish between regular holidays and special holidays. Bakit? Sabi sa batas, kung regular holiday, bayad ka 100%. As compared to, pagka yan ay special holiday at trabaho, of course, you are not entitled. So, the purpose, diminution ng income of the workers on account of work interruptions. So, under the law, guys, exclusive yung enumeration ng regular holidays sa Pilipinas. So, yeah, New Year, Monday, Thursday, Good Friday, Idil Fitir, Idil Adha, Araw ng Kagitingan, Labor Day, Independence Day, National Heroes Day, Bonifacio Day, Christmas Day, and Rizal Day. So, yung 12 na yan lang ang regular holiday. Fixed yan, exclusive. As compared to special holidays. So may be declared by law or by ordinance yung special holidays niya. Yun ang distinction between the two. Apart dun sa na-mention natin kanina as to yung compensability kapag worker hindi ka nagtrabaho. Yung example niyan, special leave of Ninoy, you have All Saints Day and the last day of year. As to exceptions, so saan hindi applicable yung holiday pay na yan, yung premium. So, again, Article 82 of the Labor Code. Second, employees of retail and service establishments regularly employing not more than 10 workers naman. So, kanina sa NSD, not more than 5. Pagdating sa holiday naman, holiday pay, not more than 10. So excluded. Next, we have service charges. So service charges, common to sa mga restaurant and sa hotels. Restaurants and hotels. So ano ba sabi pagdating service charges? All service charges collected by hotels, restaurants, and similar establishments shall be distributed as follows. 85% for all covered employees to be equally distributed among them. And yung remaining 15%, guys, for disposition by management to answer for losses and breakages. And at the discretion of the management, distribution naman sa managerial employees. So makikita nyo guys, may naka-earmark na 15%. Why? Sa hotel and restaurant industry, common yan may nababasag na plato, may nawawalang kutsara at tinidor. So yung 15% na in-earmark ng batas, yun muna yung mag-a-answer for those losses and breakages. Yung 85% naman, dinidistribute dapat yan sa covered employees on an equal basis. So, ang coverage dyan, hotels, restaurants, and similar establishments. So, all employees are covered regardless of their position, designation, employment status, so probationary or regular, irrespective of the method by which their wages are paid, except managerial employees. As to distribution, gaano ba dapat ka-frequent, guys? Not less than once every 2 weeks or twice a month. So yan, ang distribution ng service charges. How about pulled tips? May mga ganyang establishments, yung coffee shops. So wala silang service charge pero may box. So nakalagay doon na kung natuwa ka sa service nila, maglalagay ka ng tips. So pulled tips ang tawag. Ano ang ruling or ano ang doctrine pagdating sa pulled tips? Dapat yan ay monitored, accounted for, and distributed in the same manner as service charges. So kahit pulled tips yan, same sa SC or sa service charge ang treatment ng batas. Now we move to SIL or Service Incentive Leave. Ano naman tong SIL na to or yung Service Incentive Leave? So under Article 95 of the Labor Code, SIL is a 5-day leave with pay for every employee who has surrendered at least 1 year of service. So you remember guys, ang important dito ay yung at least 1 year of service. I remember around 2 years ago, meron akong nakalaban sa labor na ganyan. Nag-claim siya ng Service Incentive Leave or ng SIL. So, chinek ko, gano'n ba katagal tong employee na to sa employer at nag-claim siya ng SIL. So, nakita ko sa records, 6 months pa lang siyang employed. So, halos probationary pa nga lang kung tutuusin at the time na nagreklamo siya. So, nung nag-argue ako in favor of the employer, sabi ko sa aking position paper, hindi siya entitled dapat because sinite ko tong Article 95 ng Labor Code na ang SIL dapat available lang sa employee who has rendered at least 1 year of service. And considering that he has rendered only 6 months, dapat siya ay hindi pa entitled. So kinatigan naman tayo ng labor arbiter. Sabi niya, tama yung observation natin. Dahil 6 months lang yan, hindi yan dapat entitled. Okay? 1 year of service, so definition. As to exemptions, pinag-a-apply ang SIL so yung nasa Article 82 ulit to, ng Labor Code. With the addition ng mga employees na nag-enjoy na ng VL with pay for at least 5 days. So, question now is, entitled ba dapat ang employee sa vacation leave? Dapat ba may VL ang employees? The answer is no. So, hindi siya nakalagay sa Labor Code. Ang nakalagay sa Labor Code ay SIL or Service Incentive Leave. Pero, kung ang employee ay nakaka-enjoy na ng VL by agreement, sa contract nakalagay, may VL ka, minsan 10 days. Sa mga malalaking companies and banking institutions, they give you 15 days VL with pay. So yun ay considered na benefit mo. Hindi na mag-a-apply si SIL. Kasi si SIL nga na required ng law, 5 days lang eh. Ikaw nag-enjoy na ng 15 days with pay. So you see the distinction? Kung meron kayong ibibigay, dapat SIL, hindi required ang VL. Pero kung nagbibigay na kayo ng VL, akin to SIL na siya. Pagka yan ay more than 5 days. Equal to or more than 5 days with pay. Again, sa SIL, hindi rin applicable pagka yung iyong establishment ay nag-employ ng less than 10 employees. So yan, ang exceptions. Conversion to money. Pag hindi mo nagamit, ayaw mong, hindi ka nagkasakit, or kung BL man yan, hindi ka nagbakasyon. So, convertible ba sa cash yung iyong SIL? The answer is, yes. SIL is commutable or convertible to cash if not used or exhausted at the end of the years. Exception, domestic worker under the kasambahay law. So, pwede ma-convert sa pera. So, kung peperahin mo na lang. So, now we move to paternity leave. Paternity leave, ano yung benefit na yan? Refers to the benefits granted to a married male employee. Remember, guys, married male employee. So, allowing him not to report for work for a period of 7 days. Pero, compensated. So, 7 days leave with pay para sa mga married male employee. So, on the condition that his spouse has to deliver a child or suffered miscarriage. So, this is not limited to delivery. Pagka ang spouse mo ay nag-suffer ng miscarriage, kailangan ma-applicable din ang paternity leave mo. So, 7 days with pay yan. May nagtanong, Sir, paano po paghiwalay na? Tapos po may kabit may kabit na yung guy or meron na siyang bagong karelasyon. Nabuntis po, yun po yung mga anak. Ano po siya, sir eh. Sabi niya, pwede po ba ako mag-leave kasi po mga anak, paternity leave po. So you remember, yung paternity leave ay granted to a married male employee. At yan ay dapat legal wife lang. So hindi siya applicable sa extramarital affairs. Dahil yan ay conditions for entitlement. Employee dapat siya at the time of delivery ng child. Siya ay nagko-cohabit with his spouse. So itong spouse na to, limited to legal wife. He has applied for paternity leave. His wife has given birth or suffered miscarriage. And shall be granted every instance of pregnancy, miscarriage, or emergency termination of pregnancy. So yun. Now we move to maternity benefits law. So kanina sa lalaki, ngayon naman, we move dun sa benefits naman pag nabuntis ang isang female employee. So na-amend na to recently, yung maternity leave benefits. So dati 60-72 yung period. Ngayon, based on the recent amendment, a female member was paid at least 3 monthly contributions in the 12-month period immediately preceding the semester of her childbirth or miscarriage ay bayad ng daily maternity benefit equivalent to 100% ng kanyang average daily salary credit for a period of 105 days. At pwede pa yang ma-extend ng without pay. So, iba na. From 60, normal delivery, 72, pagka cesarean, ngayon wala nang distinction. So, regardless kung cesarean or normal delivery, yan, 105 days yan. Okay. Pag miscarriage naman, 60 days with full pay. So may option yan, yung mga female employees to extend for another 30 days pero without pay na. Okay. Kapag ka naman ang female employee ay nag-qualify pa as solo parent, so meron pa yang additional 15 days maternity leave with full pay. So, kailangan ba? So, kailangan ba pag female employee, yung spouse mo, yung husband mo yung nakabuntis sa'yo? So, kanina, para ma-avail mo yung paternity leave, dapat yung spouse mo ay yung iyong legal wife. Pagdating sa maternity leave, it is not necessary that the woman be impregnated by her legitimate spouse. It is immaterial who the father is. Every pregnant woman in the private sector whether married or unmarried, is entitled to the maternity leave benefits. Being an unmarried woman is not an obstacle for the grant of such benefits to the less fortunate. Okay? So, parental leave for solo parents, Welfare Act. Ano naman to, guys? When it comes to parental leave for solo parent, so ito yung leave benefits granted to a solo parent to enable him or her to perform parental duties and responsibilities. So, the state recognizes the difficulties being experienced by solo parents. Napakahirap nga naman, class, na magtaguyod or mag-raise ng iyong child or ng children na mag-isa. Kaya, ina-allow ng state itong solo parent leave. So, in addition to leave privileges under existing laws, parental leave of not more than 7 working days every year shall be granted to any solo parent employee who has rendered service of at least 1 year. So, remember the qualifications ng class. Kailangan at least 1 year na rin siya nagbigay ng service. So, solo parent, by definition, so, for the list kung ano ba yung nagko-constitute as solo parent, you check RA 8972. So, mga biktima ng rape, yung mga namatay yung asawa, so yung mga asawa ay nakulong for at least 1 year ang conviction, so yung mga nagkaroon ng mental incapacity ang spouse as certified by medical practitioner, so yung nagkaroon naman ng legal separation or de facto separation from spouse of at least 1 year. So yung mga nagkaroon ng nullity or annulment ng marriage as decreed by court or church, kasasa kanya yung mga anak, yung mga child or yung children, solo parent yan. Abandonment, yung mga inabandon na ng spouse for at least 1 year. So yan. Yan ang ilan sa mga nagko-qualify ay as solo parent. Take note, however, guys, na kapag ka nagkaroon ng change in the status or circumstance of the parent, so, kunyari, wala siyang asawa, pero asawa siya ulit at hindi na siya mag-isa na nagtitake responsibility for the raising of his or her child or children, yung kanyang benefits under dito sa batas na to ay mag-terminate din. Okay? So yan, na-mention na natin yung conditions kanina sa definition. So we move to leave for victims of VAUSI or Violence Against Women and Children, RA 9262. Ano naman to? So we define first kung ano ba yung violence against women and children. So yan ay refers to any act or a series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate, within or without the family abode, which result or is likely to result in physical, sexual, psychological harm, or suffering, or economic abuse. So yan yung kasama dyan pag tinatakot ka, sinasaktan ka, ina-assault ka, o hinaharas ka, at dinedeprive ka ng liberty, ayaw kang palabasin, kinukulong ka. So yan, committed by male against kanyang, hindi lamang limited sa kanyang legal wife. So pwedeng meron lang silang sexual or dating relationship. Pwede na siyang maging guilty sa VAUSI, no? Sa provisions ng VAUSI. Pero ano leave benefits pagdating dito? Kapag ka nagkaroon ng case or ng application of any protection order, kasi if you'll check RA 9262, guys, makikita ninyo meron dong sections or provisions, in particular sa issuance ng TPO or ng Temporary Protection Order, na kapag nag-grant din yung case ay na-convict siya, pwedeng maging permanent yan, yung protection order. So yung leave benefit dito, guys, ay at any time during the application, so during investigation, prosecution, and trial of the criminal case, yung biktima sa VAUSI who is employed shall be entitled to a paid leave of up to 10 days in addition sa other paid leaves under the Labor Code and Civil Service Rules and Regulations. So, yun. Special leave benefits for women. So, para sa mga female members ulit to ng workforce. Ano ba yan? Entitled yung female employee sa 2 months with full pay from her employer based on her gross monthly compensation. So pagka meron siyang sinusuffer na gynecological disorders. So such as but not limited to dilatation or with full pay, heritage, female reproductive organs. So yan. Pagka may mga issues, medical issues, ang female employees, pwede siyang mag-avail ng special leave benefits for women. Conditions, kailangan siya ay nag-render ng at least 6 months na continuous aggregate employment service for the last 12 months prior to injury. So kapag ka nag-extend naman, kailangan mag-extend, pwede rin gamitin niya yung kanyang earned leave credits. At yun ay non-cumulative and non-convertible to cash. Unlike yung kanina, yung SIL, no? Pag di mo nagamit, pwede mo i-convert sa cash. So itong leave benefit na to ay hindi convertible to cash. So yan. A woman employee can avail of special leave benefit for every instance of surgery due. So kung isang linggo, sunod, isang linggo ulit, kailangan magpahinga dahil na-operahan. Basta, maximum period niyan ay 2 months per year. Okay? So, siguro dito na tayo magtatapos sa 13th month pay. So, 13th month pay law, PD number 851. Ano naman yung 13th month pay? So, 13th month pay is a form of monetary benefit equivalent to the monthly basic compensation received by an employee computed pro rata according to the number of months within a year that the employee has rendered service to the employer. So, basta naka-isang buwan ka, no? Dun sa isang taon, pwede ka na maging entitled sa 13th month pay. So, ito yung commonly na misperceive as bonus kung tawagin. So, yung bonus ba guys, required ng batas? The answer is, generally, hindi. Ang required ng law ay yung 13th month pay. So, based on my experience sa mga na-handle kong cases, dito ako lagi nadadali ng employees. So, bakit? Kasi unlike yung kanina, yung holiday pay or yung overtime pay, kung saan ang burden of proving na nag-overtime kita, na pinapasok kita ng holiday, ay nasa employee. Pagdating sa 13th month pay, guys, ang burden of proving na bayad ang 13th month pay ng employee ay nasa employer. Anong ibig sabihin nun? Kahit na binayaran ng employer yan, kung walang pruweba, walang pinapirmahan na acknowledgement receipt, yung employer na binayad yung 13th month pay, kung yan ay through ATM sa bank, so walang proof na pinasok yung 13th month pay nila sa kanilang payroll sa banks, ang decision ng labor arbiter niyan, laging pababayaran sa iyo. So yun, ang burden of proving na bayad ang 13th month pay ay nasa employer. So, isa pang common misconception pagdating sa 13th month pay, isang buwan yan palagi, sabi ng employee. Kulang yung bonus ko. Kulang yung bonus ko. Dapat isang buwan to. The question is, tama ba yun guys? The answer is, hindi. Hindi ho siya necessary 1 month na sweldo ng employee. So may computation po yan. And under the law, it should not be less than 1/12 of the basic salary of an employee within a calendar year. So it is based on wage, pero hindi siya part ng wage. Okay, so yan, pagka marami kang absent within a year, of course, dapat tinitake into consideration yun sa computation ng iyong 13th month pay. Kasi, tinototal yan. So, dinidivide dun sa 12 months. Kaya may possibility na kung marami kang penalties and absences, mas mababa yung makuha mo. Okay. So, general rule, lahat ng employers covered yan ng 13th month pay law. As to exemptions, sino ba ang hindi cover? Employers of those who are paid purely on commission basis, boundary basis, task basis, or a fixed amount for performing a specific work, except workers that are paid on piece rate basis. Ano pa? Employers already paying their employees 13th month pay or more in a calendar year or its equivalent. So bakit hinighlight yung or its equivalent at the time of the issuance? Kasi, like I told you guys a while ago, may common misconception sa 13th month pay. So sometimes, or more often than not, ang tawag dyan ng mga employees ay Christmas bonus, mid-year bonus, profit sharing payments, or other cash bonuses. Ganun siyang nakakwalify ng employees. Common yung Christmas bonus or mid-year bonus. Again, required ba ng law itong mga na-mention ko? Generally, hindi. Ang required ng batas ay 13th month pay. Pero, kung hindi ka nagbabayad ng 13th month pay, pero meron kang Christmas bonus, so nakalagay sa acknowledgement receipt mo, Christmas bonus, at yung Christmas bonus na yun ay equivalent dun sa required ng law, yung 1/12 na computation. So yun ay considered na equivalent na ng 13th month pay. Kahit na yan ay naka-term as Christmas bonus. So in the nature yan, it's equivalent. Dun siya magfo-fall. Yan, ang computation. Monthly salary times yung month's work divide 12. Yan ang proportionate 13th month pay. So yun, siguro doon na tayo mag-end. Do you have questions, guys, sa ating discussion? Questions? Do you have clarifications? Okay na? Questions? Sorry, masyado bang mabilis yung aking discussion? Or may natutunan ba kayo? Do you have questions? Please don't hesitate kung may tanong kay chat or you can open your mic para maitanong ninyo for the benefit of the remaining na participants. Wala na? Oh. So,
yes, tanong po hindi pakarami po naming natutunan. Ako personally, as a second LS2, wala pa po akong background with labor law. Pero madali ko po siyang natindan. And maraming po ako tutunan. And siguro, I'll share mga points na nilista para sa ating lahat na din. To summarize na din your discussion po. So first, it's important for us to study labor law because in the future, magiging employees din tayo or magiging employer tayo. So, sakop tayo ng batas na ito. And also, as future lawyers, pwede nating maging practice area ang labor law, di ba? To represent our labor sectors. Ayan. And all doubts shall be resolved in favor of labor. Kasi labor, as attorney said, na labor is a property. Yan. Ni attorney property pagiging empleyado nagmamatay na so this is about employment The normal hindi exceed 8 hours. So, meron din tayong mga exceptions dyan, kagaya ng health personnels natin na talagang nawi-witness natin yan yung time ng pandemic. The reason behind this normal hours of work is para na rin sir ng ating employees and of course, to minimize unemployment. Finish din natin sa work week, sensible hours, time, travel time, overtime, night shift, rest periods, holiday pay, service charges, maternity benefits, parental leave, a month, and the others. Now, here we see and appreciate kung gaano pinangangalagaan ng ating estado ang kapakanan ng parehong employees at mga employer. And that, attorney, thank you very much po for being our guest speaker for tonight.
The pleasure is mine, and I hope that you learned something from my discussion this evening. So, thank you guys for having me as your speaker.
Okay po, may I request everyone to open their cameras for a photo opportunity with Attorney Mark. Okay.
Game po. 1, 2, 3. Isa pa po. 1, 2, 3. Thank you po.
Thank you po. And now, to award the Certificate of Appreciation and to deliver closing remarks, let me call the Vice President External of LPU Legal Studies Society, Ms. Karina Jade Ambat.
Thank you, Mary, and good evening po mga ka-LS, and good evening, Attorney Francisco and Attorney De Guzman. And to award the Certificate of Appreciation, again, to Attorney J. De Guzman and Attorney Mark Nel Francisco, in grateful acknowledgement of his distinguished and invaluable service rendered as our guest speaker in our lecture in second episode of E-Lexture Series with the theme, The Gains and Goals Denied by the LPU Legal Studies Society, held on the 26th of April 2022 via Google Meet and Facebook Live. Again, thank you very much, Attorney De Guzman and Attorney Francisco. And to formally end our event for today, first and foremost, I would like to express my deepest gratitude to our two guest speakers for today's episode, Attorney Mark Nel Francisco and Attorney J. De Guzman. Of course, thank you very much po, attorneys, for accepting the invitation of LLSS. And surely po, madami pong natutunan ng ating mga participants, most especially yung mga legal studies students natin. Kasi ito po yung mga subjects na talaga namang pinagtutuunan nila ng pansin this time of their academic excellence. And also, I want to appreciate and give my deepest gratitude to all the attendees for today's event, and of course to our very supportive dean sa palaging pagsuporta sa mga event ng LLSS. And I would like to also thank our partner organization, the LPU Lex and the LPU Cavite Foreign Service Club, for accepting the LLSS event invitation and also for supporting us. To the Master of Ceremony, of course, we have Mary, for always accepting ang event ng LLSS and supporting, syempre sa pagbibigay buhay sa lahat ng event ng ating organization. And of course, sa lahat ng officers ng LLSS, thank you for making this event possible para sa ating mga ka-LS and sa ating mga participants. And lastly, sa ating mga ka-LS, thank you very much mga ka-LS and to our attendees sa pag-appreciate and pag-attend sa ating event for today. And surely magagamit natin to hindi lang sa ating mga academic excellence and of course sa mga futures natin kasi later or sooner magiging employees din tayo and magkakaroon din tayo ng mga sarili-sarili nating property na magagamit natin yung mga na-discuss natin for today. And again, I hope to see you all in our next event and thank you very much po sa pag-attend ng ating episode for today. Yun lang po and thank you.
I'll be leaving the meeting na. Guys, thank you for having me. Kung may questions kayo, please don't hesitate to ask them. You can course them through Cody naman. Magka-chat
Thank
lang
you po,
po sa Facebook.
attorney.
Okay, bye-bye. I'll go
Thank you
ahead.
po.
Okay, so thank you so much, Miss Karine Ambat. Sorry for that. Kanina, naka-off pala ang aking mic. Pero I just want to say na sana hindi natin makalimutang sagutan ang evaluation form provided sa ating chat box. And we will send your certificates on the email address you've given in the said form. Now, to formally end this, mga ka-LS, please join us in the singing of the LPU hymn. Okay.
Game po. 1, 2, 3. Isa pa po. 1, 2, 3. Thank you po.
Thank you po. And now, to award the Certificate of Appreciation and to deliver closing remarks, let me call the Vice President External of LPU Legal Studies Society, Ms. Karine Jade Ambat.
Thank you, Mary, and good evening po mga ka-LS, and good evening, Attorney Francisco and Attorney De Guzman. And to award the Certificate of Appreciation, again, to Attorney J. De Guzman and Attorney Nel Francisco, in grateful acknowledgement of his distinguished and invaluable service rendered as our guest speaker in our lecture in second episode of E-Lexture Series with the theme The Gains and Goals organized by the LPU Legal Studies Society, held on the 26th of April 2022 via Google Meet and Facebook Live. Again, thank you very much, Attorney De Guzman and Attorney Francisco. And to formally end our event for today, first and foremost, I would like to express my deepest gratitude to our two guest speakers for today's episode, Attorney Nel Francisco and Attorney Zay De Guzman. Of course, thank you very much po, attorneys, for accepting the invitation of LLSS. And surely po, madami pong natutunan ng ating mga participants, most especially yung mga legal studies students natin. Kasi ito po yung mga subjects na talaga namang pinagtutuunan nila ng pansin this time of their academic excellence. And also, I want to appreciate and give my deepest gratitude to all the attendees for today's event, and of course to our very supportive dean sa palaging pagsuporta sa mga event ng LLSS. And I would like to also thank our partner organization, the LPU Lex and the LPU Cavite Foreign Service Club, for accepting the LLSS event invitation and also for supporting us. To the Master of Ceremony, of course, we have Mary, for always accepting ang event ng LLSS and supporting, syempre, sa pagbibigay buhay sa lahat ng event ng ating organization. And of course, sa lahat ng officers ng LLSS, thank you for making this event possible para sa ating mga ka-LS and sa ating mga participants. And lastly, sa ating mga ka-LS, thank you very much mga ka-LS and to our attendees sa pag-appreciate and pag-attend sa ating event for today. And surely magagamit natin to hindi lang sa ating mga academic excellence and of course sa mga futures natin kasi later or sooner magiging employees din tayo and magkakaroon din tayo ng mga sarili nating property na magagamit natin yung mga na-discuss natin for today. And again, I hope to see you all in our next event and thank you very much po sa pag-attend ng ating episode for today. Yun lang po and thank you.
I'll be leaving the meeting na. Guys, thank you for having me. Kung may questions kayo, please don't hesitate to ask them. You can course them through Cody naman. Magka-chat
Thank
na
you
po
po,
kami sa Facebook.
attorney.
Okay, bye-bye. I'll go
Thank you
ahead.
po.
Okay, so thank you so much, Miss Karine Ambat. Sorry for that. Kanina, naka-off pala ang aking mic. Pero, I just want to say na sana hindi natin makalimutang sagutan ang evaluation form provided sa ating chat box. And we will send your certificates on the email address you've given in the said form. Now, to formally end this, mga ka-LS, please join us in the singing of the LPU hymn. And that concludes our second episode for the E-Lecture Series. See you in the next episode on May 24th. Thank you, attendees.